If you have a will, you may think your family is protected. But here's what most people don't find out until it's too late. A will almost always sends your estate straight into probate. And in 2026, that process can cost your family tens of thousands of dollars and drag on for a year or more. In the next 8 minutes, I'm going to show you the true math behind probate, explain exactly what a living trust does differently, and help you figure out which option actually makes sense for your situation. Let's start with the basics, because the word probate gets thrown around a lot without a clear explanation. Probate is the legal process the court uses to validate your will and transfer your assets to your heirs after you pass away. It sounds straightforward, but in practice, it is slow, public, and expensive. When you die with only a will, your estate doesn't automatically go to your family. Instead, it goes to the probate court first. The court appoints an executor, usually whoever you named in your will, and that person has to file paperwork, notify creditors, publish legal notices, pay any debts, and eventually distribute what's left. In many states, this takes anywhere from 9 months to 2 full years. During that time, your family may have limited access to the assets you worked a lifetime to build. The key takeaway here is simple. A will is not a shortcut around the court system. It is actually a ticket into it. Now let's talk about the number that tends to shock people the most, the actual cost. Many people assume probate is just a small filing fee. It is not. In 2026, the average probate process costs between 2 and 4% of your total gross estate value. Notice I said gross. That means the full value of the estate before any debts are subtracted. So if your home, savings, and retirement accounts add up to $600,000, you could be looking at $12,000 to $24,000 in probate-related fees. And that's in a straightforward case. If your heirs disagree, if there are creditors involved, or if you own property in more than one state, which triggers a separate probate process in each state, those costs climb fast. Attorney fees, executor fees, court costs, and appraisal fees all add up. And remember, every dollar spent in probate is a dollar that does not reach your family. On top of the financial cost, probate records are public. Anyone can look up what you owned, who received it, and how much it was worth. For many families, that loss of privacy is just as painful as the financial hit. The takeaway: probate is not a free process. And the larger your estate, the more it costs your loved ones. So what's the alternative? A revocable living trust. Here's how it works in plain language. Instead of owning your assets in your own name, you transfer them into a trust, a legal entity you create and control while you're alive. You are typically both the trustee and the beneficiary during your lifetime, which means nothing changes for you day to day. You still manage your bank accounts, your home, your investments. Everything operates exactly the same. But when you pass away, something very different happens compared to a will. There is no probate. Your successor trustee, the person you chose in advance, simply follows the instructions you left in the trust document and distributes assets directly to your beneficiaries. No court, no waiting, no public record. Assets can often be transferred within weeks rather than years. A living trust also handles something a will cannot: incapacity. If you become unable to make decisions due to illness or cognitive decline, your successor trustee can step in immediately and manage everything on your behalf, without a court-appointed conservatorship, which is another costly and time-consuming legal process. The takeaway: a living trust bypasses probate entirely and gives your family speed, privacy, and continuity. Let's put actual numbers side by side so you can see the full picture. Setting up a basic last will and testament typically costs between $300 and $1,000 if you use an estate planning attorney. A revocable living trust, done properly with an attorney, usually costs between $1,500 and $3,500 for an individual, or $2,500 to $5,000 for a married couple with a joint trust. On the surface, the will looks like the cheaper option. But now add probate. On a $500,000 estate, probate fees in a typical state could run $10,000 to $20,000 or more. Compare that to the trust, where probate cost is essentially zero. The math is clear. The will costs less upfront, but far more in the end. There's one more thing to understand. A living trust only protects the assets that are actually transferred into it, a process called funding the trust. If you create a trust, but never change the title on your home or update your beneficiary designations, those assets can still end up in probate. This is one of the most common and costly mistakes people make. Funding your trust correctly is just as important as creating it. The takeaway: over a lifetime and across a full estate, a living trust almost always costs less than the combination of a will plus probate, often by a margin of $10,000 or more. Now, I want to be fair here, because a living trust is not the right tool for every single person. There are situations where a simpler will may be perfectly adequate. If your total estate, including your home, savings, and any accounts, is worth less than $50,000 to $100,000, many states have simplified probate procedures or small estate affidavits that make the process faster and cheaper. In those cases, the cost of a full trust may not be justified. Additionally, if most of your assets already have named beneficiaries, like a 401k, an IRA, or a life insurance policy, those assets pass directly to your beneficiaries outside of probate, regardless of whether you have a will or a trust. So if the bulk of your wealth is in accounts with proper beneficiary designations, your probate exposure may already be very limited. A will also remains important even when you have a trust. It serves as a safety net, called a pour-over will, that captures any assets you forgot to transfer into the trust and directs them there after you're gone. Most estate attorneys create both documents together as a complete package. The takeaway: a trust is most valuable when you own real estate, have significant non-retirement assets, or want to avoid a slow and public court process for your family. If you're between 50 and 70 and you don't yet have an estate plan, or if you have a will but you've never looked at a living trust, here's exactly what I'd encourage you to do in the next 30 days. First, take a full inventory of everything you own. Write down your home value, your bank and investment accounts, your retirement accounts, and any life insurance policies. Note which accounts already have beneficiary designations and which ones don't. Second, check your state's probate threshold. Many states have a dollar limit below which simplified probate applies. It varies from $20,000 in some states to $180,000 in others. Knowing your state's rules helps you understand your actual risk level. Third, consult with an estate planning attorney, not a general practice lawyer, but someone who specializes in trusts and estates. Many offer a free or low-cost initial consultation. Come prepared with your asset list and your questions. Ask specifically about the cost of probate in your state and whether a revocable living trust makes sense for your situation. Finally, if you already have a trust, review it. Laws change, families change, and assets change. A trust you created 10 years ago may need to be updated, especially if you've moved to a different state, bought new property, or had changes in your family. The takeaway: the best estate plan is the one you actually put in place. Don't let perfect be the enemy of good. A simple, properly funded trust created this year protects your family far better than a plan you meant to create someday. Here's the bottom line: a last will and testament is better than nothing. But for most people over 50 with a home and meaningful savings, it is not the most efficient tool for protecting your family. The probate process in 2026 is still slow, still costly, and still public. A properly funded living trust sidesteps all of that. The upfront cost is higher, But the long-term math almost always favors the trust. Take the time this month to sit down, list your assets, and have a conversation with an estate planning attorney. Your family will thank you for it. If you found this video helpful, the next one covers how to title your accounts and property correctly inside a trust, because that step is where most people make expensive mistakes. It's worth watching before you meet with an attorney.